Angela, I was thinking about birthdays.
Good morning.
And it's like when you turn 16, you can drive a car. When you turn 18, you can vote. When you turn 21, you can legally drink, although David. When you turn 22, it's like, Brandon, what is there?
Nothing.
It's a birthday that has no meaning. And then Angela, when you get to be Dr. Harrison's age, you just wait to die. On that optimistic note, and Angela, there's something about bankruptcy that just inspires, just makes one chipper, I guess. I don't know. Question number 1. Sydney, which of the following statements is correct regarding the voluntary filing of a petition of bankruptcy? If the debtor has 12 or more creditors, Sydney, I can stop reading. That's involuntary. Number 2, Bijou, the debtor must be insolvent. That's also involuntary. Sydney, if the debtor has less than 12 creditors, I can stop reading. So therefore, I hope the answer is D. Yes. I skipped number. Oh, I'm sorry. I'm sorry. Well, let me finish 2. I'm doing 2 now. Then Sydney, I hope the answer is D. I mean, the petition may be filed jointly by spouses and they do everything else together. Does that mean, Sydney, you could file separately?
Yes.
But as a practical matter, it would be better to file jointly. So the answer is
D.
D. Now, question number 1, which is Alex and AJ. The filing of an involuntary bankruptcy petition under the Federal Bankruptcy Code, Alex, terminates liens on exempt property. Well, no, we still have the liens. B, terminates all security interest. Well, no, because we still have the security interest because, AJ, that's how we determine who gets paid. Stops a debtor from incurring new debts. What do you think about that, AJ? As a practical matter, that's probably true because the bankruptcy becomes a matter of public record and a creditor is not going to lend you money. But that's not true legally. As a practical matter, it's true. So therefore, again, Alex, I hope the answer is D. And D says stops the enforcement of the judgment liens against property. In fact, it stops all action. So the answer again is D. AJ, you agree? Now, Katie, what do we do now? Question 3. Very good. So Michael, a party involuntary petition into bankruptcy under Chapter 7, Federal Bankruptcy Code, who succeeds in having the petition dismissed. So Michael, let me make sure I understand what's going on. What's going on is your creditors have petitioned you into bankruptcy, you have protested, and you have won. So therefore, have they damaged you? They hurt your reputation, might have stopped you from getting a loan, might have stopped you from getting a contract. So let's see what you can recover for. Megan, can you recover for court costs?
Yes.
Michael, can you recover for compensatory damages? And can you get punitive damages? So therefore, yes, yes, and yes. So the answer, Megan, is A. Michael, you agree. Now, number 4. Okay. Question number 4. David and Linda. Which of the following types of claims would be paid first? So A is secured debt, B is inventory, C is employee wages, D is federal tax lien. So David, I can eliminate C and D. Now, what I don't know, Linda, is I don't know if B is secured or not. I know A is secured, but let us assume, for the sake of argument, that B is not secured. Then the answer is obviously A, because secured gets paid first. David, you agree?
Yes.
But let us assume, for the sake of argument, that B is secured. Then, Linda, what's the answer?
Still A.
Still A, because A is before B in time. You agree? So therefore, David, whether B is secured or not, since A is first in perfection, then that means that A gets paid first. You know, Candy, what's next? Hey, who's Candy? Okay, fine. Katie, fine. Brandon, which of the following claims will not be discharged in bankruptcy? A claim that arises from alimony. Brandon, is the court very concerned about alimony?
Yes.
A claim that arises out of the debtor's breach of contract? Well, it seems like, Talini, that happens every day. There's nothing special about that. Claim brought by a secured creditor that remains unsatisfied after the sale of the collateral. So let me make sure I understand this. So I owe you $10,000 and it's secured by property. And the property, so I owe you $10,000, it's secured by property. The property is sold and we collect $7,000. It means you get $7,000. Do I still owe you the other $3,000? Brandon, I still owe her. Let me tell the facts again. She has a secured interest secured by property A. Property A is taken, the trustee takes possession of it and she sells it for $7,000. That means that there's still $3,000 in debt remaining. Do I still owe her?
No.
Do I still owe you? Do I still owe her? Do I still, I've gotten 3 no's.
Yes.
Yes. No. 4. Do I still owe her? 4 to 1. 5 to 1. 5 to 2.
Yes.
5 to 3. 5 to 4. 5 to 5. Okay. Angela, you can break the tie. Do I still owe her?
Yes.
Very good. And I think, but what's going to happen, T-Lene, is you're going to drop to the end of the line. So I still owe you 3, but you're going to drop to the end of the line with the other secured creditors. And then, Brandon, then I have a claim brought by a secured creditor that remains, I just did that one. A claim brought by a judgment creditor whose judgment resulted from the debtor's negligent operation of the motor vehicle. Well, that can't. So therefore, the special one is Brandon
A.
the alimony. So Amy, you agree?
Yes.
Now I do 6. 6. Ann and Candace. Upon the liquidation provisions of Chapter 7 and of the Federal Bankruptcy Code, certain property acquired by the debtor after the filing of the petition becomes part of the bankruptcy estate. And Candace, our choices on inheritance received by the debtor within 180 days after filing of the petition, inheritances. And generally, Candace, I don't do anything to collect an inheritance. Do I? Okay. B, child support payments received by the debtor within 1 year. Social Security payments received by the debtor within 180 days. Wages earned by the debtor within 1 year after the filing of the petition. Candace, the answer is A. And do you agree? Very good. Now, I'm thinking, Kenny, I've already done this, haven't I? Yeah, I did this last time. And then I realized it's on the tape.
Yeah.
Okay. Priority of claims in Chapter 7 liquidation. In general, all claims at a level have to be paid before moving on to the next level. If there are not enough assets at a particular level to satisfy all creditors, the trustee will pay each claim on a pro rata basis within that claim. First claim is secured creditors up to the amount raised on sale. The balance goes into the unsecured category. So let's make up some numbers here. Talini, I have a debt of $10,000. And it's secured by asset A. Megan is the trustee and she takes control of asset A and you will sell asset, you'll convert it to cash. So we get cash of $7,000. Now, Talini, tell me what happens. I owed you 10, Megan's paid you 7, I still owe you 3, but now, Megan, your 3 goes to the end of the line. Goes to the unsecured creditors. So yes, suppose, everybody agree? So yes, suppose I owe you 10, but then Megan is able to sell it for 12. So, Talini, you'll get 10, Megan, what do you do with the other two? Do you give it to me, or do you put it in the estate to distribute to others? Put it in the estate to distribute to others. And most of the time, Megan, when you sell the property, you're not going to get exactly what is owed. Most of the time, you'll get above or below. And so if you get less, then Kayla, it goes, the creditor goes to the end of the line. If you get more, then it goes into the estate to be allocated to the other creditors. Okay. And then child support and alimony. And again, Brandon, this is evidence that we have, law has high regard for there. Allow administrative expenses such as trustee fees, attorney fees, and so forth. Unsecured claims incurred after the commencement of the involuntary bankruptcy petition, but before the final order relieved by the court. Kelsey, why is it important that this is involuntary? Because I don't choose to go in involuntary bankruptcy. So it's that period of time between the creditor's file and the court grants the relief. That period of time. Those are number 4. Number 5, unpaid wages earned within 180 days. But Candy, notice that, Katie, notice that that's only up to $12,475. So Katie, what if I owe you $13,000? So the other $525, does that just disappear? For all practical purposes, AJ probably does, because you're being in category 5 up to $12,475. The additional money I owe you, you go to the last category. And probably by the time we get there, AJ, there'll be no money left. But she still has a claim. Unpaid employee benefits arising from, examples include pension contributions, health insurance contributions, life insurance premiums, etc. But again, the maximum in this category is $12,475. Katie, special rules for farmers. Consumer good deposit, for example, Katie makes a deposit with a debtor of $1,000 for a new car. So therefore, you would be in category 8 up to a maximum of $6,150. Taxes more than 2 years old. Taxes under 2 years are not discharged in bankruptcy. DUI fines, all other creditors, if there's any money left, and AJ, there will never be any money left, then the debtor gets herself. Obviously, Alex and Michael, there's a lot of horse trading here. Discuss the logic of the various categories. So Alex, why? Why do we do it in this order? Got to do it in some order, but why this order?
Well, I mean, it kind of goes in order of importance, I guess you could say, or I guess how quick it's a need. So like secured creditors obviously have to be taken care of first because.
Well, I didn't know. Secured creditors are probably the least needy. I think the child who's hungry has the most needs. But Michael, it makes sense to give secured creditors first priority, because otherwise there would be no meaning to having a perfected secured interest. But then I think society values taking care of hungry children, and so I think that makes sense. And then I think it makes sense to pay the trustee next, and then I think it makes sense to deal with employees. So therefore, Alex, your employees come after your husband and child, but before others. So I think there is some logic here. Michael, you want to add anything?
I kind of don't understand why DUI fines was on there.
Very good. So let the record reflect that Angela, he agrees. Jody is the only employee of Candace who earns $5,000 per month and is not being paid in 3 months. So 5 times 3 is $15,000. So tell me, Jody, how much would be in what category?
$12,575 would be in the unpaid wages category. And then
the rest, which would be what? 2,525? 2,525 would be in the last category with all other unsecured creditors. Which again, AJ means that she probably will get this,
Yeah.
but probably won't get that. Because people who are, AJ, financially healthy, don't go into bankruptcy. List of exemptions, assets that the debtor can hang on to. Personal assets up to $29,975, and Kelsey, that's just an odd number, isn't it? Obviously, that's a result of political negotiation. You know, one side wanted 25, one side wanted 22, so they said, 22,975, that's a good number. A car up to $36,75. Kelsey, what kind of a car can you buy for $13,75? Household goods, but not great, furniture, clothing, appliances, etc. Books, animals, but cannot be more than $575. Again, Kelsey, not much. Jewelry up to $15,500. Professional items, tools, professional books used in debtor's business, life insurance policy, and I think that sort of makes sense. Dividends and interest in any accrued but unpaid dividends and interest. Health items, we don't take away the wheelchair. Debtor can keep the wheelchair. Debtor's right to certain items. Social Security benefits, pension benefits, it should say. Pension bins. Unemployment compensation, alimony up to $1 million. Kelsey, that sounds like a lot of money, but if somebody is making $500,000 a year, that's a relatively small amount to be in a pension fund.
How can you hold on to just the $3,675 in a car?
Good question. What do you think the answer is? You'd have to sell your $30,000 car, and then keep $36.75 of the proceeds to buy another one. You're not happy with that, are you?
No.
And I should mention the bankruptcy code was changed about 10 years ago. And Michael, do you think for the benefit of creditors or the benefit of debtors? 10 years ago. For the benefit of the creditors. So this is much tougher than it used to be.
Do these numbers ever change for inflation?
No, which is another problem because these numbers have been the same for 10 years. And then the tax rates, as you know, are indexed for inflation, but that did not happen to the '86 Tax Act. Before then, inflation in the early '80s was like 10, 12, 14%. And so you could be thrown in a higher tax bracket if you were just keeping up with inflation. That will not happen now. But now, Congress has to up these numbers. So it becomes, but then who has more lobbyists in Congress? The creditors, and therefore, good luck. Debtor's right to receive compensation for losses from tort claim and educational savings accounts 529 plans up to 6225. David and Tellini, obviously there's a lot of horse trading here. David, give me the logic.
I mean, a lot of them are personal items or necessities.
And we're going to leave you with a toothbrush and a wheelchair. Tellini, spelled correctly?
I mean, they look like things that, you know, are more needs than wants.
And does it make sense? Does number 10 make sense, Tellini? I think so, because if Michael slams in your car, the $3,675 car, and wrecks it, and he has to compensate you for that, or compensate you for personal injury, that money ought not go to your creditors, that money ought to go to you. So this, I think, makes sense. But it is the law. Items which cannot be discharged in bankruptcy: taxes within the last 2 years. Taxes more than 2 years old will not be discharged if there's a willful attempt to evade. Kelsey, what if you have not filed a tax return in 5 years? So what do you advise your client to do before he files bankruptcy? has not filed a tax return in 5 years, filed 3 years of tax returns, then filed bankruptcy, and the prior 3 years can be discharged. But if he simply doesn't file, debts which are not listed by the debtor through negligence, but here, Brandon, this is, so you have, Brandon, you have 20 creditors, and you forget one. You think that's possible?
Yeah.
And I think, Brandon, somebody who runs up this kind of debt probably is not managing resources well. But here, so therefore you owe Jody's bank $5,000, and you don't list Jody's bank as a creditor, which means, Jody, your bank will not share in the proceeds, but your bank is happy about that, because now they can come after him for the $5,000. But now, let's suppose that the $5,000 that you did not list was your brother. That's probably not by negligence, that's probably by intent, and therefore your cousin or your brother will not get priority. Child support and alimony, fines to governmental unit, student loans. Student loans cannot be discharged. Did you know that? Is that shocking? It's not shocking? Why is that not shocking? Shocking to me.
Because you told us it a few days ago. You told us that a few days ago.
Speak louder so Angela can hear you. I told you, so when I told you that a few days ago, were you shocked?
Yes. Very.
Do you think, Kelsey, that the history major graduates from a Harvard with $80,000 of student debt is going to be shocked by this? Do you have any sympathy? Major was something. Items which cannot be discharged in bankruptcy: luxury goods costing more than $650, purchased within 90 days of bankruptcy filing. And again, Kelsey, that's a number. Cash advances, if more than $925 on credit card, incurred 70 days of bankruptcy filing. And that seems to me, Brandon, to be an abuse of the system. That is, I take out a credit card advance knowing that tomorrow I'm going to file bankruptcy. That seems to be an abuse of the system. Debt arising from DUI, homeowners association fees, pension and profit sharing debts related to employees, any debt obtained by fraud, and I think that is consistent with tort law, debts for willful and malicious injury, many other courts, other than negligence. And Candace, the thing about negligence is that negligence by definition is not intentional. I don't intentionally do this. I'm careless, but I don't intentionally do it, which is very different from the intentional tort. Debts which arise after the granting of the bankruptcy relief. And here, AJ, the person that loans you money after you've been released from bankruptcy is probably a fool. Because you're obviously not a good credit with. Although, and Alex, I don't know if I've said this before or not. Does anybody know what the #1 cause of bankruptcy is? Medical. Oh, I said that. Medical cost. And didn't they enact legislation to fix that? Didn't I read something in the newspapers that they fixed that? Kayla and Cindy, obviously there's a lot of horse trading going on, but Kayla, pick one, and Cindy, pick another, and tell me the logic. Does this, and again, as when Kayla is with any political compromise, we're not totally satisfied with this, but there is some logic to this, although the numbers are arbitrary. Kayla, explain the logic to me.
With taxes, the government wants to make sure they get their money.
Sydney?
With the cash advances, they want to keep the debtors from abusing the system.
How about any debt obtained by fraud? And why, Sydney, why do we make a distinction between fraud and intentional tort and negligence? Why? So therefore, if somebody sues me because I'm negligent, that can be discharged in bankruptcy. But if somebody sues me because I assault them, that cannot be, or I slander them, that cannot be discharged in bankruptcy. What's the difference?
One of them involved in tin.
And one of them, I'm just careless?
Yeah.
Now, do I choose to be careless? So arguably that's intentional, but that's for another day. Okay. Elements of a preference. The trustee, Megan, can disallow any debt which would be covered under the following. Transfer of property that benefits a specific creditor. So, Megan, you can't show preference to one over the other. Antecedent debt, fall on account of a pre-existing debt, made within 90 days before the filing of the bankruptcy filing, over a threshold of 6225, and Megan, this is sort of a materiality thing. Made while the debtor is insolvent, that enables the creditor to receive more than her share of a Chapter 7 distribution. Kobe, give me an example, and Greg, add to his example.
So you, as the debtor, sell a $300,000 house to a relative for $100,000?
And that seems to be a sweetheart deal. And the advantage of this is I'm going to lose everything I have, but at least we keep it in the family. Greg?
I was going to use the example of selling a car cheaper to a relative.
So making anything that treats one creditor differently from another. One Kobe, criteria number 5. This has to happen while the debtor is insolvent. And insolvent means I'm unable to pay my bills as they become due. My current liabilities are more than my current assets. Why is that an important criteria, Kobe?
Because if you're solvent, then it would alter your decision making.
And Kelsey, if I'm solvent, it's harder to prove that this is intentionally trying because if I'm solvent, and then I have a medical condition that forces me into bankruptcy, but I didn't know about the medical condition at the time I did the sweetheart deal, the selling the house for a discount, then I wasn't thinking about the bankruptcy when I did it. Yes?
So could you do that before you did a voluntary bankruptcy? Like if you voluntarily filed for bankruptcy since you weren't insolvent, like you don't have to be insolvent. File for bankruptcy.
Well, that's true, but
Or would this still?
but if I'm solvent, the Megan's argument, Megan is the trustee, her argument that I'm doing this to disadvantage or to advantage, and actually I don't need to R there, because if I advantage Candace, that means I disadvantage Kobe. So treat one differently from the other. It's harder for Megan to prove that if I'm solvent. June the 1st, Megan was involuntary petitioning into bankruptcy. She owned and operated a camera store. Taylor was named as bankruptcy trustee, and the bankruptcy court granted an order for relief on June 30th. So note the date. Megan, the proceeding started on June the 1st. The court did its order for bankruptcy on June 30th. So Megan, what's going to go on? What's going to go on during the month of June?
Bankruptcy, child support?
Okay, so therefore, they petition you into bankruptcy, you have the opportunity to protest, and then if you but you don't have to protest, you could just agree, but that gives us time for the court to decide if they're going to grant the relief or not. So the claims and expenses of the bankruptcy estate are, and if you've got the notes printed out, you might, or if not, you can look on the screen and go back. So let's go through and classify each one of these and tell me what category, 1 through 11, each of these goes into. So Megan, fees earned by you. That would be category, so category 1 is secured creditors, category 2 is alimony, category 3 is Megan. So that would be category 3. And then fees earned by the attorney would be category 3. Administrative expenses. Claims by secured creditors, that would be 1. Unpaid wages within the last 6 months, that would be category 5. And then claims by Katie, we'll come back to Katie. And then claims by general creditors, that would be category 11, the last one. So Megan, what you're gonna do is you're gonna take the property secured by this property, you're gonna convert it to cash, and then start making a distribution. So now let's look at Katie's claim. And also, Katie, remind me of the dates. We started on June the 1st, and the order was granted on June 30th. So that month of June is kind of iffy land? Okay. So now, the claim by Katie was for accounting equipment ordered on June 3rd and delivered on June the 29th. Answer the following question. Katie, do you have a secured claim?
I said no because it was in those 6 months, but I'm not sure if that affects my security claim.
So, but the question, Katie, is not whether you have a secured claim. The question is, are you in category 1 or a lower category? So do you, so yes, use the language before. Katie, has your claim attached? Yes. Now, is your claim perfected?
Yeah.
Well, let's assume that you've done a financing statement. If we assume that you have done a financing statement, because this is not a PMSI, because you're not buying for a merchant for personal use. So it's not a PMSI. So assuming that you've done a financing statement, then you have a secure claim. But now, the next question is, Taylor, what category is she in? Is she in that first category, or is she in the later category?
She's in 4.
She's in 4.
Mm-hmm.
4 is unsecured claims incurred after the commencement of the involuntary bankruptcy but before the final order of the court. So that means that, let me think about this. That means, Katie, you will get paid after all 3 of these, because you're in that never never land. So that being the case, Taylor, if the bankruptcy stage, Taylor had $41,000, then who's going to get paid first? And let's see how much will be left for Katie. So we got $41,000, and who will get paid first? Okay, Taylor? The secured creditor. And here, Taylor, I have to assume that when Megan takes the property, she sells it for at least $5,000. So therefore, $5,000 goes to them. And then the administrative fees, which I think were $25,000, is that right? 10 plus 15. So we started with $41,000. And we paid $5,000 here. And we paid $25,000 here. So Katie, help me with the math. 41 minus 5 minus 25 means you get $11,000.
Was they gonna keep 2,300 because it's camera equipment and she's a photographer? And like professional items are even, like, you can get 2,300 of professional.
Yes. Yes, they can keep up 2,300.
Or does that-
Well, we don't. Here's what we don't know. That's a good question. Here's what we don't know. We don't know whether, my interpretation is that this is inventory. That it says that you own a camera store. Doesn't say that you're a photographer.
Okay.
That makes sense.
So it wouldn't matter
Or
with
maybe.
inventory, it would just matter, like if, like inventory wouldn't be professional.
That's right. So now, if Megan, but that's a very good question. If Megan was a professional photographer, Megan, then you can keep part of the equipment. If you're not a professional photographer and simply inventory, which Selene, I think is the better interpretation here, then it would be converted in cash and so she wouldn't be able to keep any of it.
So would it be considered a personal asset? That's, I think, why I did the problem wrong, because you can keep up to 22,000 something.
I didn't see any personal assets here.
Like for photography equipment, but I guess it's.
No, well, again, if you're a professional photographer, then you could keep your professional tools. But under the assumption that this is your inventory, you could not keep any of that. Which is why, Megan, you'd rather go into a chapter 11, because under with chapter 7, you lose everything that you have, because chapter 7 is a liquidation proceeding. So Taylor, you're the trustee, you'll take all the property and convert it into cash. Under chapter 11, a trustee would be appointed, and what you will do as a chapter 11 trustee is you'll run the business. And if you think about that, Megan, the creditors may, not only would you prefer chapter 11, but Sydney, I think the creditors would also prefer chapter 11 because it's in the interest of everybody for the business to keep running, for her to keep selling equipment, keep selling her cameras and other inventory to generate future cash flow. Because if we do chapter 7, once they order it, then it's a cutoff date and everything's converted into cash. Maybe that answer your question. Next question. How many should be different if Megan's order with Katie be placed on May the 28th? Taylor, how is that different? May 28th is before the filing of the involuntary petition for bankruptcy, which means that she would be treated as the other secured creditors, which means, Katie, you would get paid first. Everybody agree? Taylor, how would your answers be different if Megan's order with Katie had been placed on July the 4th? First of all, why are you working on a national holiday? I mean, what's your problem? Have you no patriotism at all? How would that be different? Okay, Taylor, that's July 4th. Remember, the order was granted on June 30th? So now she's an unsecured creditor. Which means what, Taylor? Katie will not participate in the bankruptcy at all, because this debt was created after the order for the bankruptcy. So Katie will not participate, nor will Megan the debt be canceled.
How come I'd be unsecured?
Well, you'll be unsecured until you do a financing
Until
statement.
the financing.
So in some way, Candace, she might be better off that the order was placed on July 4th. Because if the order was placed on May 28th, she's in better shape than if the order was placed on the 10th, but she's still only going to get a portion of her debt. If the order is placed on July 4th, it's outside the bankruptcy. Another advantage of Chapter 11.
For that first
Yes.
scenario, did you say she was a secured creditor for that, so category 1, you said?
I'm sorry, say again?
For May 28th, what did you say she'd be classified
For
as?
May the 28th, she would just be a regular secured creditor, as soon as she does her financing. Assuming she gets the financing statement done before June the 1st. So in other words, if you go back to the original data, Katie's claim would be lumped in with the claim of the other secured creditors, which means, Taylor, Katie will get paid before you get paid. But I think there's plenty of money to go around so far. Kelsey, this is something about bankruptcy that just kind of, bankruptcy and divorce, it's unlike. Brendan, bankruptcy and divorce, it's human nature at its best. Linda, that's why I went into tax. Chapter 11, corporations, debtor, and creditors formulate a plan under which the debtor pays a portion of his debt and is discharged of the rest. Same debtors as are eligible under Chapter 7. However, there's a fast track for Chapter 11 for small business debtors whose liabilities do not exceed $2 million, who do not own or manage real estate. And then they would simply work out with the trustee a settlement of the debt. For others, there's a creditors committee, and there's a reorganization plan, and Taylor, you would be appointed as a trustee that will run the business. Plan must be fair and equitable to all parties within 120 days after the date the relief is granted. So Taylor, the relief would be granted today, and within 120 days, you have to report a plan to the court of how you plan to take this business out of its current situation. So basically, Megan, you're the debtor. You will cede control of your business to Megan, who will run it for you, make all managerial decisions until the plan is fulfilled. Now, the advantage of this, Kelsey, is that two advantages. The advantage to the debtor is that she continues in business. The advantage of the creditors, Kobe, is they get paid not only with the money at hand today, but the money that will come in during the reorganization period. Acceptance of the plan, confirmation of the plan. The confirmation is all the creditors agree. If they don't agree, then the court will order them to agree, and then it's all carried out. And then, and the court, Taylor will designate a period of time, a year, 2 years, 3 years. Kelsey, the timing would depend on the complexity of the business, how much debt is owed, how much cash flow is coming in. Kelsey, if the debt is $10 million and the cash flow is $1 million a month, we could probably settle this quickly. If the debt is $10 million, and Cindy, the cash flow is $100,000 a month, it will take a longer time to do. Taylor, you like that better because you have more work to do, therefore you get paid more. And typically the trustees are who? Either CPAs or attorneys. Chapter 13. Individual repayment plans, not for partnerships and corporations, for an individual with regular income who owe fixed unsecured debt of less than $383,175. Kelsey, obviously the result of political compromise there, or fixed secured debt of $1.1 million. Katie, what does it mean by saying regular income? Usually that means one thing. It means salary, wages. However, Megan, can you think of a person who has regular income? For example, Megan, in most cases, your camera shop would or would not have regular income. When we say regular, Katie, what do we mean by regular? Predictable. But your camera shop could be up and down, so that would not be regular income. Can you think of something, Megan, that produces regular income other than wages? And even wages, Katie, may not be regular, depending upon if you're an hourly employee and sometimes you get to work overtime, sometimes you don't, then David, that might not be regular. But Megan, can you think of a type of income that is regular other than salaries?
Tax income for the government?
I'm sorry?
Tax income for the government?
Like what?
That's as good as I've got.
How about rent? So Linda, you are a slumlord and you own 10 apartment units. Is that pretty regular income? Can you predict that? Yeah. But other than rent and salaries, I guess you could, what about, Kelsey, what about a gym where your primary source of income comes from gym memberships and you've got a regular clientele? Then that's probably somewhat predictable. Who determines, Kelsey, whether it's regular or not? The court. Chapter 13, filing a petition by voluntary prohibition by court conversion of Chapter 7 based on substantial abuse. And here, Kelsey, you remember that the court prefers 11 or 13 to 7 because the debtor can keep more of her assets and the creditors get more money. So therefore, Cindy, you're the bankruptcy judge and you think somebody's trying to take advantage of the system by following Chapter 7 before they come into a big sum of money. So you could order them based on the substantial abuse test to go into Chapter 13. To be forced into Chapter 13. There's an automatic stay, Taylor, just like with Chapter 7. Repayment plan, turnover of trustees, such future earnings that execute the plan. Full payment through deferred cash payments on all property claims. So therefore, you will take charge of the business. You'll make all managerial decisions. You'll pay off the creditors on a prearranged plan. Identical treatment of all claims within a particular class. Debtor must use the means test to determine disposable income, which means what, Cindy? You have to have money to live on. And therefore, and how much do you need to live on? Are you married? How many children do you have? Do they have medical issues, etc.? And therefore, you're going to put together, Megan, you're the debtor, you're going to tell the court that you need at least X dollars to survive. And then Cindy, you're the judge, you'll decide how much she'll keep. And when I say keep, I should say, Taylor, how much you will pay her. Length of the plan, 3 to 5 years. Could be shorter if the debt are less than $2 million. Court holds hearing, witnesses come in, court listens, and so forth. Generally, all debts are dischargeable except claims for domestic support obligations, debts related to injury or property damage caused by DUI. And again, Kobe, this is because we don't like drunk driving. Allowed claims not provided by the plan, certain long-term debt provided by the plan, certain tax claims are not dischargeable. Next time we'll do a review of bankruptcy, and we'll talk about how you can be petitioned into Chapter 7 involuntarily. See you next time.